report in relation to this matter. I think we are all present. I see Karen Hamilton from Brody's on behalf of the council and the 4 council attendees. I was expecting Paul Campbell's just joined us on behalf of Joan Campbell, I think, who's the landowner, and Adnan Azam in respect of other property rights. And I think Adnan, the property is owned by Aish Property Limited. I don't know if that's the right way to pronounce the company name, if that's accurate, Aish.
Yeah, that's right.
Good enough. Good enough. Out of interest, where does the name come from? I'm always interested in why people choose company names.
IS is a new company. I've got several companies.
Okay.
In the group of family companies, we have about 3,000 properties.
Oh, wow.
So, IS is actually my son's 2 initials from his first name, and then my daughter's name. So I made it for them. So when they get a bit older, I have a company with maybe 100 properties in it.
It's so often the case, isn't it? There's a story behind each company name. Okay, well, that's fine. Well, thank you for that. What I'll do is I'll just ask Lucy just to confirm when we're going live and recording, and I'll do make a few introductory remarks. Then we'll get the meeting started. So I'm just happy if everyone else is for Lucy just to indicate when we're going live.
Yep, we're all good.
Yes. Good morning. My name is Paul Coquette. I'm a reporter appointed by DPA to report to ministers in relation to the North Lanarkshire Council, Blocks C, D and E, Millcroft Road, Cumbernauld Compulsory Purchase Order 2023. This is a pre-inquiry meeting held under the Compulsory Purchase by Public Authorities Inquiries Procedure Scotland Rules 1998 in relation to this proposed compulsory purchase order, which proceeds under the Housing Scotland Act 1987 and the compulsory purchase powers under the Acquisition of Land Authorisation Procedure Scotland Act 1947. I'll ask parties represented and interested today to introduce themselves in a moment. First of all, I'd like to make just a couple of introductory comments to set the context for this morning's meeting. This obviously is a virtual pre-examination meeting, and accordingly I'm proceeding on the basis that participants are consenting to the recording of images and uploading to the DPA website for the purposes of data protection and GDPR. We'll proceed informally this morning, certainly as informally as possible, and at a pace that particularly the objectors are comfortable with. I appreciate for those who are objecting to the order and the nature of this sort of examination is likely to be an unfamiliar procedure and process for them. I want people to be as relaxed and make this as informal as we possibly can in the circumstances. If anything, in particular from the objectors, is unclear or you're uncomfortable about, just say, and we'll try and clarify those issues as needs be. We're set for a meeting of 2 hours this morning. Whether we'll need 2 hours depends how the conversation and discussion goes. I wasn't particularly planning to have a break necessarily. Sometimes it's a good idea to take breaks on virtual meetings of this nature. But if anybody wants a break at any time, again, just say, and we can take some time out for whatever reason, if it's thought to be appropriate. And equally, for those who are unfamiliar with the procedures that we're looking at today, if anybody has any questions, please just ask either on the chat bar or just by interrupting any proceedings if anything, as I say, is unclear to parties. You'll all have seen the relevant notice letter issued by me on the 21st of September. The purpose of that is to set the context of the process and set the time clock going under the 1998 rules and in terms of target dates for DPA for reporting to ministers in relation to matters under consideration today and when we get to the full oral procedure. The purpose of today is not to read any evidence, but it's to set out the procedural arrangements for looking to consider in some form or other. As you're all be aware, I think there are documents that are lodged on the DPA website that can be accessed. I've got some of them up on screen just now, but if anyone needs to access them from today or from now on, they can be seen on that. And for the record, they can be accessed by going to the DPA website and searching under reference CPO-320-1. So, with those words of general introduction, I think I'll ask Karen Hamilton of Brodie's, who are instructed on behalf of the North Lanarkshire Council, to introduce herself and her witnesses.
Yes, thank you, sir, and good morning. So, as you say, my name's Karen Hamilton. I'm a partner at Brodie's, and I'm representing the council in relation to the CPO and at this morning's meeting. And also with me from the council team are 4 representatives. We have Nicola Laughlin, sir, who's a solicitor with the council. Also, Joanne Saunders, a solicitor with the council. Natalie Henry, who is a project development coordinator within the Place division. Essentially, Natalie Henry is the PM, the project manager for this project, and Katrina Arbuckle, who is a development officer also in the Place division, sir.
Thank you. And Anna Azam on behalf of IES Property Limited, if you could introduce yourself.
That's as simple as it is.
That's it. He uses that.
I went through a CPO recently.
All right, okay.
Karen probably doesn't remember, but Karen, we did have Brodie's acting for us, and yeah, we know Brodie's are very good, so we are up against it from the word go.
It's a small world sometimes that we're operating in, and I take it you're a director for what you said earlier on. You're a director of IES Property Limited, yeah. You don't have your own legal or other representative with you today or later.
No, we will get it when it becomes required.
Okay.
Typically, you know, the properties in this area are not very low value for what thousands will spend trying to fight a case.
Yeah.
I don't see any benefit trying to get solicitors involved.
Yeah.
Like I said, we had a recent CPO in Glenrothes in the Glenwood Shopping Centre, and Brodie's were acting for us, and I obviously know fees can come to, and there's no point in that. I don't find any benefit for anybody.
Okay, right, thank you. If that circumstance changes, just let us know, and we can then take things forward from there. Yeah, and Mr. Campbell, I should say first from IES, my understanding is that the IES Property Limited are the owners of numbers 66 and 75 Millcroft Road that are relevant for this.
Yeah.
That's the ones, yeah. Okay, thank you. Mr. Campbell.
Yes, good morning. I'm Paul Campbell. I'm representing my wife, Joan Campbell, and we own properties 68 and 73 Millcroft Road.
Yeah, that's fine, thank you. I take it you're representing, just as our partner, you don't have any professional qualifications. You're not a lawyer yourself, or representing in any other manner other than just representing.
No, I am a professional person, but
sure.
not from a legal point of view.
Okay, no, that's fine. Thank you for that. And parties should be aware that there were originally 3 objections in relation to this order, but the third objection that was referenced in the relevant notice letter, the objected in that case, has withdrawn their objection. Okay, the suggestion I made on the letter of 9th October issued by the DPA case officer set out an agenda for the meeting. We've had a couple of communications by Brodie's in relation to the agenda on 12th of October and earlier this week. And we know we'll get an update in a moment from Brodie's in relation to the kind of statement of case. First of all, just invite anyone to see, other than the details that we'll get into of what the points that Brodie's are making and the relevance of that to the order, whether anybody has any other comments or suggestions in relation to the agenda for today. Let's start with Brodie's.
No additional matters, sir.
Okay, thanks. For IES, are you happy with the agenda?
Yep, no problem.
Yeah. And Mr. Campbell?
Similarly.
Okay, right, thank you. I think probably in terms of item 1 on the agenda, I've got a couple of questions in relation to the objections, just for my completeness of understanding, but it might be as well just to go straight to the position in terms of the North Lanarkshire Council statement of case and information that's going to be provided. There are a number of issues that have come to my mind when considering the papers here, but probably it'd be useful just to get an update on what the council position is in relation to the update to the statement of case and other factual information. I know there's a reference to The planning position was going to ask about planning and other information in relation specifically to Joan Campbell's objection on antisocial behaviour. I think you may be in a position to update me as to where you are in gathering further information in that regard. So the board needs to update on the case, statement of case.
Yes. So the intention is to submit a supplementary document which will supplement the statement of reasons as a statement of case, and the intention was that will update on several matters. So perhaps if it's helpful for me to outline, sir, just the factual position with the properties at the 3 blocks in the first place, and we can give an update on that. So 20 flats have now been acquired by the council, so that's 20 out of 169 in total.
Right.
And 19 owners or households have been relocated to the new flats, which we've been referring to as the Burns Road development, which those are the new flats developed by Sanctuary Housing Association, which are referred to in the statement of reasons. That development was completed this summer, and so 19 households have now relocated there. 41 flats at the 3 blocks are currently empty. It's you can appreciate that's a position that changes day to day, if you like, or week to week. But 41 properties currently empty, and 76 owners or households have indicated that they wish to be rehoused by the council and are either have now been placed on the council's housing register, or the council are engaging with those households to receive applications for them to be placed on the register. In relation to planning, sir, as you mentioned, a proposal of application notice for the council's proposed scheme was submitted in June, on the 30th of June. The PAC process proposal, the application consultation process was completed, involving 2 public consultations during the usual 12-week period. And following on from that, the council has been working with its design team to progress the detailed design proposals. It is anticipated that the planning application will be lodged in January now, sir, which is a timescale which has slipped somewhat from the initial indications in the statement of reasons, but that is where we are with that. The council is anticipating a 4-month determination period, but as we know, that's a timescale that can't be guaranteed. In terms of the survey report that I had also mentioned in email correspondence, so it is planned to update the Hardy's survey report. That an earlier report was prepared in 2019. An update to that report has been instructed, and we are anticipating that the written report as an outcome of that updated survey work will be completed by the end of November. So, and available to be circulated and lodged, obviously, in process. In terms of the antisocial behaviour information which you mentioned, sir, further information was provided to Mrs. Campbell in a follow-up to the queries that were raised as part of her objection, and I think from the council's perspective there's nothing further outstanding on that, but it would certainly be anticipated that as part of the inquiry documents which would be lodged in due course, that information concerning antisocial behaviour as part of that would be lodged in the inquiry process.
Okay. Yeah. That's very helpful. Thank you for that. We'll come in a little while to the question as to when the next oral procedure or the appropriate oral procedure is going to be, whatever it might end up being. But those are useful indications in all those respects. It does suggest to me that if we are looking to proceed reasonably quickly, and I have to say, just from the outset, I was coming anyway to the view that my original aspirations of trying to be pressing ahead with a fairly imminent public inquiry, I think are probably overly ambitious. So we're certainly talking about into the new year, but it looks a little bit as if the planning position will not be resolved by the time we get to a planning inquiry. I notice that as one of the objections relates to prematurity in proceeding ahead of that. So that ground of objection, that issue of objection looks so that will still be there. In terms of the survey report, if that's available by the end of November, then that's less of a problem if we have an inquiry into the new year. And I'm grateful also for the update in relation to antisocial behaviour data. Again, that's important. And while this plays again into the form of the examination, it does strike me that some of the information provided in relation to past antisocial behaviour and questions as to whether the level of past antisocial behaviour still subsists and therefore still justifies the order is very much the basis, I think, of both objections. Have a concern about that. I'm grateful for the update in relation to where we are on documentary evidence. I should say, I'll invite the objectors to comment about this in a minute. One of the issues that was in my mind looking at the documents in relation to this, and particularly thinking about social behaviour, but applies to other aspects of this as well, is that in Joan Campbell's objection, she talks in terms of the council setting, I think the phrase she used is a lot of rhetoric. And certainly from my reading of the papers, there's quite a lot of information about what the council decided. What's less clear to me at this stage is the evidential basis for reaching those conclusions. So there's lots of words, and that may have some relevance to the form of the format of the examination. But the objectors' points really relate in particular to antisocial behaviour, and it may well be we are going to have to see not just documents but have evidence-led in relation to the kind of evidential basis for the council having reached that view. It's clear from the objections, and we'll talk a bit more about the wider nature of the objections, that the concern is that some of those are not adequately evidenced. So I just want to put you on notice to the council that some of those points about the documents, in one sense, there's quite a lot of, if you like, secondary documentary evidence. That is, the council committee decided X, Y, and Z, but there's not an awful lot of primary documentary evidence that led to that recommendation to the council committee, if you see what I mean. The council evidence of the council committees is important. It's important that I have that, but it's also important in terms of the justification for the order. Given the nature of the objections, that I get a full understanding of the kind of factual and evidential basis. That might point us towards more of a full public inquiry than a hearing, but we'll come to discussion about that. So I wanted to say that in the context of the various points that you have made. You made there in terms of the evidence that's been gathered. I'll stop now and ask the objector, starting with Mr. Azam, what do you have anything to say on that particular point? We'll go on to other issues in a minute, but anything arising from what the council said or my response, Mr. Azam?
Well, I want to keep it short. I don't want to
sure. Don't worry.
Long about it. But I do think the council are setting a scene that this CPO is already a done deal. And I think the behaviour has been questionable, approaching tenants through different departments and saying to the tenants, we're looking to relocate you. It sets a mindset that the CPO is going ahead, and that's what's happening. Everybody's moving. We've already heard from Karen, 20 properties have been bought, and 76 people are moving. We have to understand the demographic in this area. These are people with low incomes or on benefits, typically in my experience. And when they're getting offered a new house and they're getting offered to get out of these flats, they're obviously going to take that, and they're going to obviously express their interest of going to a new block of flats, because that's great and in a decent area. Like you did say about that antisocial behaviour, I don't see that as owners. An owner's duty. That's a police matter and a council matter to enforce this. And that's what I've been saying for many years around this area, that these fly tipping, we can't prove that these are coming from the flats. This could be anybody just fly tipping. The council have CCTV cameras. They should be reviewing the footage and enforcing, doing some sort of enforcement. They should have signage. Then the council typically just blame the owners. And the council have not mentioned there is a factoring going on in this blocks. The factoring, there's many owners were paying £15 in to a factoring, and I can't remember the lady's name of the top.
Don't worry too much.
I think it's Elaine. She was cutting the grasses, she's cleaning the blocks. But my point comes back to one more point. I don't want to keep going on and on, but when we talk about common repairs, there's an obligation on every landlord when they register the property to fulfil that they are going to contribute to common repairs. Okay, the lifespan of roofs, the lifespan of building materials. Yeah, there is a lifespan. A roof typically, in my view, 25 years is a good roof. Nobody's replaced these roofs. If the council don't know some of the owners of these properties that they put in the documents, they can't find out who the owners are. How are we, me and Paul Campbell and so many other owners, going to find out these other owners? We don't have the resources the council have to try and find owners. And the common repairs, like I said to you, nobody's done anything over the years. There should have been an enforcement, in my opinion, from the council. The council should be trying to do the repairs or enforce the missing scheme, saying to the owners, and then use, we'll pay the other bill and we'll chase the owners. There is such a thing as missing scheme, and it works quite well in Edinburgh City Council. But the council have never ever touched on this basis. That is effectively my point. Like there was a fire in a block, and in my point I made out, the council have dwelled on this point and taken pictures of the fire. A fire can happen in any block. A fire can happen. Any kid can set a block on fire. And this happens in, well, I live in Kirkcaldy, and you know 2 or 3 big buildings nearby the high street that have been set on fire by young kids. That doesn't represent anything about the area. It can happen anywhere. And the council have taken pictures, and my point about the pictures was they seem to have just shown the negatives and not the positives. Because in my opinion, the odds, when you drive in and you turn to the left, the odds are in good condition and well kept, in good manner, and then the evens are in a poor manner, I feel. And all the houses, and individually, I'm happy when we go around to the site visit. I'll take you to the properties.
I'm going to come to the site visit question in a minute.
There's nothing wrong with the houses inside, but that's because us as landlords, we make sure they're up to standard, and we make sure they're always renovated and made sure the tenants are happy. But we're not going to keep contributing to the blocks to get them done up. Nobody's going to pay £3,000-4,000. Already in the block of 66, there was a fire in there, already painted it, already replaced some of the lighting, and it cost me the best part of £600. And Paul said that he would pay a contribution. All the owners in that block, me and Paul have this one in that 66 block each. Paul offered to pay a contribution to it, but nobody else did. Everybody else was ignoring us.
Obviously, we will deal with these substantive matters in more detail, you know, when we get to the full hearing. It's certainly useful to get a sense of that, and that sense that you have. And I'll come back in a wee while again. This is the purpose of this just now is to set a framework to allow an understanding of what the council need to establish at the hearing. The actual detail of whether they have or not, we can deal with at a later point. So thank you for that, Mr. Campbell. Do you have anything to say just about the issues raised by Brodie's on behalf of the council, or my questions there on that kind of the nature of the evidence, not, as I say, the substantive evidence we're looking at, but anything arising from the nature of the evidence?
Yeah, I think you touched on it quite well. I think we just feel that it was, as the previous objector was saying, it's a bit of a done deal. The council feels as it has already established that this is going to go through. As you've said, people are being incentivised to leave. You know, so we know people in various blocks who have been incentivised, either intimidated by getting, you know, CPOs going to go through, everybody gets scared and gets stampeded a little bit, and then there's a positive incentivisation for the owner-occupiers in particular. And I would say at the outset that we understand why the council are concerned about these blocks of flats. So we're not saying that this is the utopian place to live. However, what we would say, and what we've tried to say in our objection, is that the worst of the times, the bad days, are in the past, and quite a bit in the past. And the people that are in the flats just now, they are nice properties inside, by and large, and certainly we maintain good standards. We have tenants who have been in there for a long time, no intention of leaving, and we feel that it's quite a stable population between tenants or owner-occupiers. It's just the council are now trying to incentivise things, and all that will happen is the greater the proportion of empty properties, the greater the tendency and the risk for antisocial behaviour, for more fires to be started. People will then start to naturally be worried, and then they will then start putting their hand up to say, well, I want to be relocated as well. So it creates its own situation, and we feel as well that that the council has other mechanisms, and the landlord registration system. Presumably that's there for a purpose, because we are certainly responsible landlords, and we know a lot of other responsible landlords. But the problem with all properties is that there can always be a rogue element, and it's how you actually handle that rogue element rather than branding everybody as being rogue. And there's been no efforts, as far as we can see, to manage the situation through the Scottish Landlord Register by basically banning rogue landlords, which does happen.
Okay, thank you. I mean, that's hopefully be helpful to me to get a kind of a framework and understanding of the issues, and will assist the council, I think, when we come to the question of the oral procedure itself, as to the sort of areas of activity and areas that require to be addressed in the evidence that's led in due course. I had a couple of follow-ups on the objection. One actually again addressed to Karen Hamilton. In terms of the documents, I've got on the papers before me a kind of reasonably full letter of objection for Irish property dated 27th of April, and a letter from Joan Campbell dated the 8th of June. That correspondence has been responded to by the council. What I don't think I've got on the file are the initial letters of objection that I think by the timings should have been lodged for the 23rd of April. So it looks as if there probably is other correspondence. Now, that other correspondence may just say I object, and certainly the objection grounds are set out very fully in the two documents from the respective objectors that I've referred to. But if there is an earlier document that says anything of substance on the objections, it might be useful if that just be lodged with me. Maybe I've missed it, but those letters set out very, very fully what the objections are, but it may well be there's a formal letter of objection earlier in the system, and it would be useful if that could just be submitted to me by the council in due course. My second question related actually to what Mr. Campbell's really just said. In fact, both objectors have alluded to, and that's the question of the position of tenants. According to the schedule of service, I think number 73 in Millcroft Road, which I think is one of Joan Campbell's properties, wasn't shown as tenanted. One of the questions for the council, just to be absolutely sure, and I think there have been certificates lodged, just to be clear that you're satisfied that all notice has been given to all the relevant tenants and occupiers, obviously other than less than 1 month, which you don't have to in terms of the 1947 legislation. I saw there was certificates of service lodged, but I didn't actually see those referencing a certificate of service on the tenants of these affected properties. So again, if Brunus can confirm now, and if they can't confirm now, maybe we could confirm in due course to make sure that you're satisfied that service on all tenants who have an interest under the 1947 Act has been given. And related to that, the question as to whether you're satisfied that any change in tenancies arise between the service of the order in April and when it's ultimately submitted for confirmation, those other tenants are duly notified, if that makes sense. So I take it you're satisfied with the steps that have been taken in respect of the tenants' interests.
Yes, sir, we are satisfied that all steps have been taken in accordance with the 1947 Act requirements in relation to tenant interests or occupiers. Generally, notices were hand delivered to each occupier at the addresses at Millcroft. And as you may be aware, site notices were also placed.
Yes.
But we can, I mean, if it's helpful, sir, what we might do is prepare a short summary document, just pulling together the sort of service methodology as a document that might be lodged with the inquiry or hearing documents, just so that you've got that explanation in a single place for looking back at it in due course.
That could be useful. And we may come to some of those issues as far as notification of the date of the hearing, specifically in relation to the properties where there are unknown owners. Just to be, I know I've seen the affidavits and the information provided, but we'll come to that. I take it any service such as required to stand as security holders, you're also satisfied that anything, because there may well be security holders in relation to some properties, not necessarily the objection properties, but some property might have securities. But I presume, again, the interests of security holders are kind of accommodated or considered in the council's approach to this order.
Yes, they are considered, sir. I think I'm right in saying that at the point of service of the CPO itself, security holders don't need to be notified, but that comes at a later stage in the process, and that would certainly be done if we get that far.
Okay, that's my understanding as well, but I'm just keen to ensure that we don't overlook the interests of others, tenants and others.
We certainly have a schedule has been prepared, sir, which captures those interests as part of the general interests in the blocks, and that's maintained by the council.
Okay, that's fine. My next question, which is moves in, I think, into item 2 of the agenda, is we'll get your statement of case in a couple of weeks, and that'll be hopefully very helpful. I'd welcome views from the council as to whether you feel it's necessary that the objectors formalise their letters. I've mentioned the letters that I've got them, maybe earlier letters as well, whether they should formalise their objections into a statement of case. I, for my part, am content to proceed on the basis of those 2 letters, rather than put unrepresentative objectors to the trouble of turning the same wording into a statement of case, unless they want to be saying something different in their objection. But I don't know if you have any views as to whether you'd be content that from this part of the process onwards, we work on the basis of those 2 letters that I've referred to, or whether you think there should be anything more that should be added.
I think I appreciate the point you make that both letters of objection are all in their terms. I think that there are certain things that a statement of case would typically do in terms of giving notice of potential witnesses and the objector's intentions in that respect. Appreciate witnesses are something which is on our list for the agenda this morning. I think what it might be helpful to get clarification on from the objectors is if there are any areas of their objections that they're no longer insisting upon, or if they appreciate that the objections as a whole are they're taking forward, but there's quite a lot of material in those objections, and it may be that some of the issues have been answered by the previous exchanges that have been had, particularly where they may relate to, I think from the council's perspective, perhaps a misunderstanding of certain things in relation to the scheme that may now have been clarified. And so it would certainly be helpful if we were able to just hone in on what the key areas are, but I think from the council's perspective, we wouldn't be insisting on or suggesting that the objectors should have to prepare a document in a certain format, because I appreciate if the objectors are unrepresented, that may be unnecessarily onerous, but it would be useful if we could narrow down the issues in dispute, if indeed that is the case.
That's very helpful. I would say to the objectors as well, just as I've indicated to the council, that I have an expectation that full evidence and full justification is provided. If the objectors are wanting to lead their own witnesses, and we'll come to preconditions and various things in a moment, I'll not be expecting witness statements from the individual objectors standing before me today. But if they do wish to call their own witnesses to the oral procedure, then the same rules would apply to them that would apply to the council. And equally, what's of some importance, when we look at the full set of documents that are going to be before me, and the relevant notice letter gave an indication as to notice of the documents 4 weeks ahead of the oral procedure, that applies to the objectors as well. So if you want to rely on your own documents, you need to lodge them with DP and the case officer, give fair notice and let me have time to read them as well. So that may go some way to meet the point made by Karen Hamilton there in response to the question of statements of case. I think it would make sense if there were issues that either objector is not insisting on, that we focus, which helps me focus in on the kind of main issues of dispute. I will issue in due course a broad agenda, which, whatever format the oral procedure is, with what I see as the headings. I'll issue it in draft so people can comment on it. But what I will do is set out what I see as the headings. I'll move to the objectors just for comments on that, and in particular on the suggestion that if there are any grounds of objection not insisted upon, that I can an indication is given as soon as you reasonably can. You may want to see the council's updated statement of case first, but by the end of this month, you give an indication if there's anything you're not insisting on. But first of all, Mr. Nazam, anything on that?
I couldn't comment on my objection now. I'll need to sit down, review it, and then come back to the council if there's anything that I am satisfied with in the objection. I believe that we can take out. But like I said, at this point, I can't comment. I'll need to look through it.
I think you need to actually come back now and see which bits you might not be insisting on. The key thing is exactly what you've just said, is you look at it by the end of this month, if you could indicate to me and to all other parties if there are parts of your objection. I think you have 11 grounds of objection in your case. If there's any that you're accepting and not insisting on, clarity and a focus on the main issues would be useful. So thank you for that, Mr. Campbell.
Yeah, it goes back to the very opening statement you used, well, one of the opening statements you made. There's a lot of rhetoric from the council, not a lot of substance, and so therefore the basis of our objections still stand, because we've never really had clear-cut evidence to prove one way or another to allow us to withdraw any of the objections.
Okay, thank you. Right. I think we can move on to the question then of what is the appropriate procedure. I know the council have been suggesting an in-person hearing to be held rather than a virtual hearing. I should say that I'm slightly kind of torn between the best way forward in this case, and one of the reasons why I'm torn ties into the question about the fact that there may be some factual or historical pieces of evidence that might go beyond documents that might need to be laid. And so my question, I'm going to address it first of all to the council, is what their view on whether we should hold a virtual oral procedure or an in-person one, and also specifically whether the circumstances of the objection warrant a full public inquiry, or whether they warrant a hearing. For the benefit of the objectors, a full public inquiry, and specifically this is important because it will require full evidential precognitions or statements from the council witnesses that can be subject to cross-examination by the respective objectors. So it's a kind of a full kind of cross-examination type inquiry, or whether, as is frankly more common these days, it proceeds by way of a hearing. The difference with the difference between the two is effectively a hearing would require not really recognitions or statements. The council's witnesses would only be attending and would really ask questions where I lead on the question asking, rather than the objectors. And the objectors are entitled to ask questions, but they ask them through me. So the principal, if you like, interrogator of the council's case is me in the case of a hearing, whereas in the case of a full public inquiry, the primary testing of the evidence would be for the respective objectors. And in this case, it does strike me that there's pros and cons to each way of proceeding. And the reason I roll this together is if it's a more full public inquiry type procedure, that is often better done in person than it is virtually. It's not possible to be done virtually, but it can sometimes be regarded by parties in particular as easier if done in a kind of an in-person environment. So starting with the council, it would be rolling both those questions together, what your views as to the best way to address the issues would be.
Yes, sir. I think the council remains of the view that matters in this case can be dealt with sufficiently at a hearing. There are certainly a number of areas that have been raised by the objectors, but the council's view would be that the hearing process would allow those matters to be looked at in an efficient manner. It's more user-friendly for the parties, sort of particularly if the objectors are not intending to be represented. Cross-examination can be quite an onerous process for parties, particularly unrepresented parties, to have to deal with that. And so far as we're aware, there hasn't as yet been any suggestion that there will be competing expert evidence in any of the areas, Esther. So it's not one of these occasions where, so far as we're aware at the moment, certainly that you would be having to sort of test the credibility of respective expert witnesses in that way. So the council would certainly be anticipating making its full suite of relevant witnesses available at a hearing if it were to be a hearing, and that they would be there to both give their views and have their evidence and opinions explored, but that would be the most efficient and user-friendly way for the process to go forward. So that's the council's position on format, sir. Yeah. It also remains the council's preference that it would be nonetheless an in-person format. I suppose a few reasons there. I think partly it remains the case that while the virtual processes can work well, and particularly for something like today when we're going through the procedural agenda, but for the occasion of the hearing, it does allow better communication between, I think, all of the parties involved, and particularly where there would be a number of witnesses on the council side, certainly, to allow ease of communication on the day. I think again with the parties, if it's the case that they are going to be unrepresented, they will be having to manage a lot in the way of documents, because inevitably the council will have a lot of documents which will be lodged in due course. And when trying to manage those in an online format with perhaps documents on screen, parties on screen, it can lead to difficulties if parties don't have a representative helping them with all of that. And added to that, the possibility that there may be technical difficulties on the day. These things can all be overcome if, for example, we're in a hall with a paper set of documents available for parties to fall back on. It's a little bit different when perhaps there's a solicitor helping parties and managing a lot of that for them. But I'm quite conscious of that, having had the experience in other cases, that it can become difficult. So I think that's another reason why the in-person process would perhaps work better in that respect. So I'll leave it at that for the moment, but those are our initial
Before I go
views.
to other parties, just one other question. I'm conscious Mr. Azam said he lives in Gregory. I think Mr. Campbell is perhaps more local to Cumbernauld. One of the questions, I guess, is where would an in-person process take place? It couldn't take place in a council office. It has to be in a neutral venue. So I suppose my question, is also a request. Is there anywhere in the Cumbernauld area, as I'm going to be travelling from home away anyway, so convenience maybe, we're not going to go to the townhouse in Gregory for however desirable that may be for him. It may be that we would look to you to be looking at sorts of halls that might be available, or accommodation that might be available. It's not a council premises in the Cumbernauld area, but I simply don't know what options there are there. So I'm going to plant that question just now rather than necessarily expect an answer. And Karen, you may not know the answer to that question. I'll maybe go to the objections just on the question of the kind of format. I emphasise with the format, either way, I would ensure as far as I possibly can that the objectors get a fair opportunity to have their questions asked of the witnesses, whether I'm in charge of the kind of the agenda and the questions. I'm generally pretty relaxed about allowing people to ask questions through me to test the issues properly. But I know we're getting into slightly technical stuff, but Mr. Azam, first of all, any thoughts on, as I say, the question of whether you think a full public inquiry is appropriate, and what your preference are for in-person or virtual?
I'm happy with either, to be honest, but at the point of we come to an inquiry, I would be represented by a legal body. I would be interested in doing it myself at that point.
Yeah. Okay, that's very helpful. But you did say that earlier on this morning, so thank you for that. Mr. Campbell?
Yeah, we'd be probably happy either way, but probably with a preference towards the hearing on a virtual basis.
Yeah. Thank you. That's helpful. The other question, all of this, and we may not actually be able to get an answer to this question until we get all the full information in the documents in, is how long that's going to be needed. And it may well be at this stage whether you have an answer to the question of at least in principle, of where we might hold the hearing. It may well be that we have to just allow the council to come back with their further statement and investigate the possibility of locations. As I'm reasonably flexible about doing that, but I don't know if you have an answer, Ms. Hamilton, on the question as to the where.
Yes, sir. We did some initial thinking on that, and that the council team has been involved in some previous inquiries around the area, and on those occasions, I think local hotels have been used. And so two options which have been suggested as possible venues to investigate are Castle Cary House Hotel and Westerwood Hotel, which I believe are both in Cumbernauld.
Okay, that's and the documents in relation, all the documents presumably will be available at council headquarters, or when we get to an in-person inquiry, if we did that in the inquiry room itself. So to be capacity to be having the documents there. Okay, well that's pretty helpful. I mean, the question this all ties in to a certain extent is the question of when it's likely to have the hearing. We're certainly talking, I think, probably now looking at towards the end of January into February next year. I suspect the earliest realistic to give the council an opportunity to update the statement of case, to get parties to assess that, and then think in terms of their own documents. And when it comes to instruct representatives, so it may well be that we're looking at a date around then. It's probably quite difficult to say how long is going to be needed as well. Again, that's a bit dependent on documents. I mean, it strikes me as likely we might need either 1 or 2 days. I don't think we're going to need more than that. I suspect, again, insofar as anybody can tell in advance, people might have different views on that. Maybe well be we just explore those dates and locations and then look to fix that a little bit nearer the time.
Yes, sir. In terms of timescales, I was also coming to the conclusion that February seemed more realistic. I suppose as an earliest point. Appreciate obviously the desire to get things moving along, but I suppose January would bring its own difficulties just with the lead in to that, then backing up into December with the difficulties over the holiday period. So I think February would to some extent ease those difficulties, as well as allowing for the planning process at least to have moved forward in the sense of documents hopefully being lodged. In terms of duration, I appreciate it will be dependent on a number of things, including whether any of the issues perhaps fall away. But I was thinking perhaps a day to a day and a half. So that's, I think, largely chiming with your own thoughts on that.
Yeah. Okay. Any thoughts from other parties? In particular, are there any periods which are not going to be convenient? If you have any sort of other commitments that would take out periods, as the council say, too early in January tends to get caught up in kind of holiday season timings and various things. So end January or end in February. But if there's any dates, and you don't have to say now if you're not sure, but if there's any dates within that sort of time frame that don't work, just let me know. So I don't know if the objectors have any comments on looking at that sort of time frame or scale of inquiry.
February's okay for us, and it's better than January. So I agree with earlier comments.
Sam?
Yeah, typically it's the 9th to the 19th. I'll be away with my kids abroad for holidays.
Yeah, I suspect I'll be as well. My children are well and truly grown up, and wife works in a school, so I'm still stuck with the school holidays. So it may well be the February week. I'll be doing different things as well. So we'll note to avoid the 9 to 19th, which I think I want to avoid as well. So thank you for that. Okay. When we do get to the stage at which we have a date for an inquiry, what we in DPA would do is give public notice in a newspaper. I think the notice of the order was given in the Gazette. Is there a newspaper circulating in the Cumbernauld area that would be useful for notice of the inquiry?
Yes, sir. I think previous notices have been placed in the Cumbernauld News and Cocythe Chronicles. That's one newspaper. So Cumbernauld News and Cocythe Chronicles.
Okay, that's fine. Neither are periodicals I'm particularly familiar with, I must admit, but that's useful nevertheless to be aware of that. No, thank you for that. And tied with that, I would generally request the council when we reach the stage, and we'll do the newspaper advertisement. That's DPA's job. We will give you wording of what notices was going to those newspapers. What I would request is that the notice that we give you in due course is put on the council's website. And again, thinking about the question about unknown owners, if you could arrange at an appropriate time for a site notice with the wording we will give you in due course to be put up on site, anybody else living in the area, whether known owners or unknown owners, can be aware of the date of the inquiry once fixed in due course. So if you could attend to that in due course, that would be much appreciated. Right. I'm just looking at the agenda here. Oh, hang on, clicked the wrong thing. The issues around the agenda. Well, I think we've covered actually most of them. We've spoken about the same principles of data protection and GDPR will arise. We will try to webcast the hearing. I'll need to check with our IT team whatever date is chosen that there's availability. That's going to be true for a virtual as well as in person that's webcast. Mr. Azam's mentioned already legal representation. And the only other thing I'd say under item 3 of the agenda is just for the benefit of parties, and Mr. Azam may want to note this for telling the lawyers he instructs in due course. My own personal practice at the end of a hearing or a public inquiry is not to expect parties at the end of that hearing to make closing submissions on the last day, which is always a great relief to lawyers involved in this. My general practice would be to set a time scale, whatever it might be. We'll decide at the times, often it's 7 days. Where parties then submit closing submissions after that. So I'll say more about closing submissions, and we'll make decisions about closing submissions when we get to the hearing. But just to put you on reasonably fair notice that whatever we decide to do, I'll not be expecting closing submissions at the end of the actual hearing itself. Is there anything else on item 3 about procedure? We can't take it any further than this just now, I suspect.
Nothing from the council.
Okay, that's fine. Items 4 and 5 we've really covered already on the agenda. Documents and recognitions. I've nothing really to say in relation to that more than what I've said already, as set out in the relevant notice letter. The extent of the detail of the recognitions will depend on the procedure that we decide to adopt, and I think we're kind of veering towards a hearing just now. If it is a hearing, I'll make a final decision once I've seen the statement of case in the council and further documentation. My practice is at the very least to ask that any council witnesses who are going to be attending don't necessarily lodge recognitions, but just lodge a document giving their names, their professional qualifications, and the areas of expertise that they can speak to. That just assists me in a hearing in knowing who to direct questions to. So at this stage, we may not need more in a way of full evidence in a recognition, but even just a document, if that could be prepared in due course, just as I say, indicating the roles have been described today in this meeting, but the roles that those witnesses play. And again, that will apply if the objectors have their own witnesses, expert witnesses or other witnesses they want to come along to give any testimony. I'll not be expecting the two objectors themselves to be lodging recognitions, but if they're relying on other documents or other witnesses, as I've said already, then they'll need to comply with the requirements of fair notice, as mentioned previously. So that hopefully is clear from that perspective. And a list of witnesses that follows from the same on the same basis. The next question, which we may be able to make a bit of quicker progress on in the overall timescale, is the question of the site visit. I would quite like to come and look at the properties, certainly from the outside. And from the objector's point of view, they may not feel constrained to do this, and there may be tenants in residence there. I'm very happy to look in the insides of their properties if they want me to, but I'm keen to have a site visit and do that if that were possible. Do that in the kind of period immediately upcoming. Obviously, ideally, I'd want it to be accompanied by one or other or both of the objectors, not least just picking up Mr. Azam's point on I'll get this right, the odd numbers are perhaps not poorer state than the even numbers. Forgive me if I've got that the wrong way round.
Other way around. So that
I knew I'd do it. I knew I'd get that one wrong. Whatever, it would probably be useful given I've seen obviously the photo, there'll be a series of photographs lodged, but it would be very useful if the objectors could be there just to point out those issues on site. Again, a bit like today, not really meant to lead evidence as such at a site visit, but an opportunity for me to be there and get a sense of the case for the council in relation to the state of the property, but also the position for the objectors. So I think an accompanied site visit I would find immensely helpful in order to do that. I was kind of slightly hoping I could do this towards the end of this month, but again, I don't know if that that will be convenient for any parties. And I was thinking of, I think, the 21st or 22nd of November is a Tuesday or a Wednesday. I don't expect it would take more than an hour. If it was either of those dates, I'm happy to come through. I'm Edinburgh based at a time that's kind of convenient for all, either 10 a.m, 11 a.m. But I don't know if parties would be okay, with the arranging of a site visit, say on the 21st of November, and around that sort of time frame. Again, you might not necessarily know, since I've kind of sprung this date on you. If you go away from this meeting and find you've got some other commitment that's completely stymies that, feel free to just come back. But in principle, I'd welcome views as to whether coming through, say, for 10 a.m. on the 21st of November would be something that would work, starting with the council.
Yes, yes, sir. I think that date would be convenient, and I think an accompanied site visit is sensible in the circumstances. I think from the council side, I think there would be 2 council representatives. That would be Katrina Arbuckle and Natalie Henry, who are on the call today. And actually, I would attend that myself, albeit just in a watching role, obviously not saying anything really on the occasion. As I outlined at the beginning, obviously the council has now acquired a number of flats within the blocks, and so we would be able to make available to you, the chance to view a sample of those acquired properties, which may be useful.
Okay, Mr. Zahn. Does that work?
I would be very happy with him to be on site. I think the point about acquiring properties and showing you certain properties, that's no reflection, back to my point, of good landlords. That's poor landlords, and that's an enforcement issue for the council. And whether they've acquired them or not, that's nothing to do with us. And like I said, they might be poor condition properties, but my properties in particular are very good condition, and the block that we're in, we try to keep it in good condition as well.
Okay. Actually, on that point, I'm going to get a further question from Mr. Zam in a minute, but on that point, I mean, there is an issue, and I direct this to the council, not to answer it now, but in terms of what we examine when we come to the oral procedure in due course, is, this is an acquisition of quite a lot of property, and as has been made clear, its status, the quality of the property, the behaviour of landlords, all varies across different sets of circumstances. So one of the questions that is in my mind that potentially would require to be addressed is, if you've got individual owners, landowners or tenants who've not been, if you like, guilty of any of the conduct or behaviour that has given rise to the general desire to take this property into public ownership, why should they lose out? Why should their ownership rights be impacted upon negatively in the greater good? So effectively, although they've done nothing wrong, because the only way in which you can really acquire this is acquire it all. How that plays into the public interest justification for the removal of private rights. I just say that because it's an issue Mr. Azam has reminded me of. It's in my mind anyway, as to how that public interest in acquiring the whole block plays in, even if justified for the majority. Hypothesising that it is justified for the majority, how does that justify the taking of land of the minority for whom those criticisms do not apply? So I just flag that up rather than necessarily looking for an answer at this stage, but it's one of the issues that's in my mind about the overall justification for the taking of the order. So I say that as a slight diversion from this particular topic. My question, Mr. Azam, is, are you okay with a site visit on the 21st at 10 a.m? Does that give you enough time to get through for a start?
No problem.
And if you want to show us your property from the inside, I should say, for all people, the extent to which it's of value seeing other property, I'll leave to parties. But anybody who wants me to look at properties that happens not to be in the ownership of people on this call, obviously it's your responsibility to get appropriate consents in order for that to be done. Mr. Azam, I think I cut you across. As if you're about to say something else.
No, I'm happy.
No.
I'm happy with a site visit. I'm happy with the date and the time. It's not a
Yeah,
problem.
that's fine.
We can work
Okay.
with
And Mr. Campbell?
Yeah, I was checking with my wife there. We're going on holiday at a point in time, but not on the 21st of November. So we are available,
Okay.
and 10 o'clock's not a problem for us.
Excellent.
There's one point I want
yes,
to clarify while we're talking about the blocks, and is the CPO open to acquiring certain blocks and leaving certain blocks, or is that something that you could actually make a decision on? These blocks should be bought. These blocks I don't think the CPO should be granted for these. Or is it,
Strangely enough, that is my next question. I haven't put it on the agenda, but the power that ministers have are either to diffuse the compulsory purchase order or to confirm it or to modify it. So there is a power that ministers have to proceed by way of modification of the order. That was actually the next item I was going to go on to before we finish the meeting. This will be an issue, I think, for the hearing itself, but it is open. It is open for ministers to confirm with modifications. And Mr. Campbell had his hand up there.
Yes, well, I'm glad that it moved to this point, because it's a point that we raised in our objection at the beginning, which was that 169 flats. It's quite a scale of development, and the bit that looks worst in the whole development is the sort of the common area, right? So you haven't seen the flats yet, but there's basically big blocks of flats, and in front of the flats there are sort of a row of garages with a big public footpath over the top of it. Now, those garages and the footpath, those belong to the various. That's part of the common area of the development, and when you see it, that's the worst part of it. It's the most neglected, but it's actually a big public footpath that everybody uses. And to me, it was, I'm a chartered surveyor in property, a quantity surveyor, and just always seemed to me to be crazy that when the original development was disposed of, it seemed to me a natural demarcation point that the blocks of flats are one thing with their common areas, but the actual garages with the public footpaths on top of that seemed to be almost like a distinct part that would have been better retained in the public interest and better looked after for the public. So so to me, there's the blocks of flats, two different sets of flats, if you like, but then within the flats there's the buildings, and then there's the non-building parts of it as well. So I just flagged that separation up.
Okay, thank you. And Karen Hamilton, anything further you want to say just on the question of the modification point? I saw you nodding earlier on, but again, I'm not looking for a substantive answer now, but that may be something that the council would wish to think about, topics to be addressed when looking at that issue of the potential, at least, for modification.
Well, you're certainly correct. So that the order may be modified in due course. The council doesn't have in mind that obviously any modifications are required as matters stand. If the position were to change on that and the council wished to propose a modification, obviously we would update you on that. But there's certainly the council does not take that view at the moment. So just to backtrack slightly,
Yes,
you were appreciate that this isn't the place to be getting into submissions or the substantive issues. But I've noted what you've said about the number of properties, the issue of behaviour, sort of bad behaviour, good behaviour. You'll be aware from the council's statement of reasons there are a number of strands to this case, antisocial behaviour being one such strand, but one of the key planks running throughout the whole thing relates to clearly the condition of the common and shared areas, the difficulties of dealing with those, and we will make submissions in due course as to how that all hangs together and justifies the action that the council has taken. But the case does not simply rest on one plank, and indeed you may form the view that if the council were to make out any one or more of those planks, that the case would be made, but that's clearly a matter for submissions, etc. Can I make one final point, sir? Just going back to the issue of precognitions, I appreciate this is a procedural point, but the council's preference remains for a hearing. You've heard the objectors; they seem to be, I think, neutral on the procedural point. But if you were ultimately to opt for the inquiry process, you said that the Mr. Campbell and Mr. Adnan wouldn't have to produce a precognition. If there are to be precognitions, I would like to have advance notice of what they are going to say, even although they may not be technical witnesses.
Yeah, okay.
And particularly, Mr. Campbell has mentioned a QS background, and clearly, if he were going to be giving evidence in that capacity, we would want to know about that.
Okay, that's fine. I'll deal with that then once at a point taken, and accept that. I'll look at that and address that if that's the line that we end up going down. I was going to go to say actually, in respect of the issues, and this is I'm just going to say a couple of things that are in my mind. I will, in due course, whatever the format of this, circulate a draft for comment on the kind of a focusing in what seemed to me to be the main issues. But I too had picked up the issues on my reading of the papers, and certainly confirmed by this call, is that antisocial behaviour is certainly one, but not the only one. The question about decision-making options the council have taken, and legitimacy of those decisions, including refurbishment, and whether that's been properly examined, the cost of repair, and the cost of repair compared to the value of the properties. I noted the point was made that the cost of repair exceeded the value of the properties, but I couldn't see anything about the value of the property to make a comparison. The question of IA's property and their awareness that this was happening by virtue of being a relatively recently having acquired the property, issues about alternative steps, and that's the landlord registration schemes, and the operation of that, adequacy of consultation, issue arising of compliance with the qualities duties and the Fairer Scotland duties, as well as the issue of modification, and a point about the rehousing strategy as well. So yeah, except that there's a wider range of issues. Now I'll write that down more formally. You don't have to scribble it down quite just yet. I'll write some of that down once we're actually a bit closer to a hearing or a public inquiry date. But those are the sort of the key issues that I've seen in my mind as arising. And lastly, in that respect, just again to give notice to the council in terms of the sort of documents that it's up to them what they produce, but had come to my mind as being relevant. I did notice, and there was a complaint about the compliance with equality impact assessments. There's a reference to the quality impact assessment, but it's not actually lodged. So you might want to think about whether you want to lodge that. In relation, in particular, to the Irish property, there's reference to how Mr. Azam should have known about the CPO. I don't think, and there's reference to that of documents on the title sheet that should have alerted him to the upcoming nature of the CPO when the property was acquired, but I don't think his title deeds are lodged. So again, you might want to think about just giving some substantive evidence to support your position. There's reference to local housing strategy 2021 to 2026, and it may be that at least relevant extracts of that might be useful to see. There is reference, and I'm not suggesting this necessarily be lodged, on housing need and demand assessment. I don't really think I want to see, and I suspect that's a vast document. If you are relying on that, to any extent, some evidence of that might be quite useful, as well as what you decide to produce in terms of antisocial behaviour evidence. Now, those are matters for the council to decide what they lodge, but there is reliance on these documents, and I would quite like to see the documents on which the council rely for myself, so that I can look at them in the course of this examination. Mr. Campbell.
Yeah, just a couple of brief points.
Yes, of course.
Hamilton mentioned it's like, so I am a chartered QS, but I wouldn't rely on that as an expert, if you like. Obviously, I've got opinions, but I'm not going to try to out-expert anybody, if you like. You can make up your own mind. And very lastly, I am very glad to hear about your comment about value for money, because that was one of the grounds of our objection. Comes back to the whole point of rhetoric from the council. It's like they make these statements, but they haven't necessarily proven the point, to my mind anyway, about value for money. How do you assess that? What is the money, and how do you assess value, and then put the two together? So it's, you know, it's easy to say, but it has to be demonstrated. So I'm glad you picked up on that. Thank you.
Sam, anything more? I think we're on this point, and then we'll just, I think we're
The surprising part, with the title deeds, that was nothing to do with us as a company. We did clarify that with the council. We provided them an update of that. I don't know what happened, but land registry had delays on their end, and in that, and we provided the submission, application, and the dates, and from the solicitor forwarded it on to the council. So they accepted that. I think I'm satisfied the council have done everything in their means to inform me about the CPO. In particular, I think it's Karen Cowie. She's been on it quite a lot.
Yes, our case officer. Yes, here.
Yeah. She's been on top of everything. There is one slight element, and I don't know if you can comment on that. My surprise is the council's willingness to discuss with owners like myself and Paul. It seems to be, if we're objectors, we're unfavoured, we're somehow dehumanised, and we're not good people. We've objected against the status quo, and we should not be spoken to. Whereas they've purchased these properties of other people, have people come with a begging bowl and ask them, buy the property off us. Please, we want out, give us the property. Nobody's ever approached me, nobody's had dialogue with me and said, look, let's sit down, let's talk about this, and let's see what we can maybe get some middle ground in this. Albeit I've objected, they could come to me and say, look, my main goal here is to ensure at the end of this, if the CPO does go ahead, it's not financial. I'm not bothered about the financial side. I'm more bothered about the two tenants who have been loyal to me, who've been paying rent on time, who are very good families, that they are rehoused properly as well. That's one of my main goals of this whole objective, albeit that I don't agree that the properties are in poor condition. But like I said, nobody's approached us and nobody's had dialogue with us, and it seems like we've been left out and we're just a small cult aside.
Okay, well, I'll bring in Paul Campbell now, then I'll say something that I'll let Brodies respond to that if they want to. Mr. Campbell.
I'm just going to sort of briefly just add to the previous comment without labouring it too much. But yeah, I mean, I think the bit that seems to be forgotten about, it seems that the paperwork, it takes time to generate, and I get that, it takes time to generate momentum, but it seems to be the paperwork is a throwback to something that doesn't exist in the current day. Okay, it did exist back in the day, doesn't exist now, and we are a bit bothered about the condition of our tenants, if you like. Pretty much most of the people in the blocks of flats now are decent people. They always have been decent people by and large, and there's been a fair proportion of owner-occupiers in there as well, helping to maintain standards. And it was a shame for them where there was any antisocial behaviour, because it just affected everybody. But generally the people are good people, and we have got, for example, we have got a new tenant in another property we have in Cumbernauld who's leaving Millcroft because he feels scared and intimidated about Big Brother is actually in the CPO. He just sees the writings on the wall. So he's actually given up a lease to come to somebody else, and you're going like, well, that's just actually internal relocation within the council. It doesn't actually solve a problem as such. So yeah, so our primary aim is not to try to get in the way of progress. If we really thought that this was a rubbish block of flats with rubbish living conditions for our tenants, then we would be at the front of the queue waving the flag. We just don't share that belief.
Okay, thank you. And I'm conscious that when people come in to a kind of a formalisation of the process, and somebody like myself gets appointed, that does actually create a different, slightly more formal dynamic between objectors and the authority. And so, there's a degree to which communication, for example, with my office has to be copied to everybody to ensure procedural fairness. So it does change the dynamic a little bit. But I'll maybe ask if Brodie's want to say anything more generally about cross communication between parties, objectors, and those who don't object.
Yes, sir. I think certainly there's no difference in approach to the council's willingness to discuss the process or updates or anything to do with the project in terms of whether someone is an objector or not, or their status at the blocks. I think perhaps what Mr. Adnan might be alluding to is the council's strategy in terms of its approach to purchasing properties which were landlord owned, to put it that way, which is something which is set out in the council's rehousing strategy, in that there was a deliberate approach taken to focus on relocation of tenants where that was possible, and also owner occupiers, clearly because of their circumstances. But in terms of advance purchase, voluntary purchase of properties, the focus was not at this stage on acquiring landlord-owned properties just because of financial exposure, etc., of the council. But the council's approach to all of that is set out in the rehousing strategy document. It's not something which has come about as a result of objections being received in this process. The council is certainly happy to speak to any of the objectors about the process and the project at any point in time, and that hasn't changed. And I think there are quarterly or something thereabouts sort of updates that go out from the council to all affected parties.
Okay, thank you for that. One thing that I allowed the conversation about site visits to drift off the topic that I want to raise. I don't think there's anything else necessarily that is in my mind, at least, that we need to raise today. The one thing about the site visit is just to ask the council, for the site visit we're doing 21st of November, I would find it beneficial if a circulation could come out to parties of a kind of fairly precise meeting point as to where the appropriate place to gather together on the day of the site visit. I've had experiences where things are left a bit vague, and sometimes people are wondering about not knowing quite where they're going. But if you could think about and identify a precise location, that would be helpful. So that's all I think that's in my mind for today. I'll do a short note in relation to, I think, the 3 action points that we have from today's meeting that I'll ask Karen Cowie to circulate. But is there anything else that anybody wants to say before we formally close the meeting?
No.
Shaking of heads. Well, thank you all for your assistance this morning. I find it very helpful just to get these kind of procedural things aired, and be in touch in due course in relation to later procedures. So thank you for joining the call today. Thank you.
Thank you.
Thank you.
Bye.
Thank you.